Hello everyone. Today we will be discussing some multiple choice questions on Transfer of Property Act 1882, which is a part for your business laws. So, without wasting much time, let's start with our video. Question number 1. In which of the following cases is rule against perpetuity not applicable under the Transfer of Property Act 1882? Option A. In case property is transferred for the benefit of lineal descendants. Option B. In case property is transferred for the purpose of construction of a winery. Option C. In case property is transferred for the purpose of creating a temple promoting Sati. Or option D. In case property is transferred for building a library for comic books. The correct answer for this question is option D. In case property is transferred for building a library for comic books. Question number 2. In which of the following cases will the Puime mortgagee has no right to redeem a prior mortgage? Option A. Puime mortgage is invalid. Option B. Puime mortgage is time barred. Option C. Puime mortgagee has lost all remedies of foreclosure. Or option D. All of the above. The correct answer for this question is option D. All of the above. Question number 3. Section 5 of the Transfer of Property Act 1882, option A, applies to property sold in auction sale. Option B, does not apply to property sold in auction sale. Option C, applies to compromise of doubtful rights. Or option D, does not apply to compromises of doubtful rights. The correct answer for this question is option B, does not apply to property sold in auction sale. Question number 4. Section 99 of the Transfer of Property Act 1882 deals with option A, provisions related to charges on property. Option B, provisions related to anomalous mortgage. Option C, provisions related to mortgage by depositing of title deeds. Option D, none of the above. The correct answer for this question is option D, none of the above. Question number 5. Subrogation as defined in Section 92 of the Transfer of Property Act 1882 can be option A, conventional. Option B, legal. Option C, either option A or option B. Option D, neither option A nor option B. The correct answer for this question is option C, either option A, conventional, or option B, legal. Question number 6. The basic ingredients of the doctrine of pendens are option A, the suit should be collusive. Option B, property should have been transferred or otherwise dealt with. Option C, a litigation should be pending in a court of competent jurisdiction. Or option D, the suit must not be related to a specific immovable property. The correct answer for this question is option C, a litigation should be pending in a court of competent jurisdiction. Question number 7. The doctrine of pendens, option A, is applicable on both movable and immovable property. Option B, is applicable on both partial and absolute transfers. Option C, is applicable on both specified and unspecified properties. Or option D, all of the above. The correct answer for this question is option B, is applicable on both partial and absolute transfers. Question number 8. The English law, option A, recognizes the concept of Universal Donee. Option B, recognizes the concept of universal succession. Option C, both option A and option B. Or option D, neither option A nor option B. The correct answer for this question is option D, neither option A nor option B. Question number 9. The English rule against perpetuities deals with option A. Interest to arise in future. Option B. Interest in present. Option C. Both option A and option B. Or option D. Neither option A nor option B. The correct answer for this question is option C. Both option A. Interest to arise in future and option B. Interest in present. Question number 10. The English rule that a grant should be construed most favourably to the sovereign, option A, is applicable in India in its totality. Option B, is not applicable in India. Option C, partially applicable in all the cases in India. Or option D, partially applicable to some of the cases in India. The correct answer for this question is option B, is not applicable in India. Question number 11. The first draft will or Transfer of Property Act 1882 was made by option A. First Law Commission, option B. Second Law Commission, option C. Third Law Commission, or option D. Fourth Law Commission. The correct answer for this question is option A. First Law Commission. Question number 12. The forfeiture under Section 111G of the Transfer of Property Act 1882 can option A. Not be waived off except by express declaration of the same. Option B. Can be waived off by acceptance of rent becoming due after forfeiture after the suit to eject lessee has been initiated. Option C. Can be waived off by accepting of rent becoming due after forfeiture in case lessor is not aware that forfeiture has incurred. Or option D. Can be waived off by accepting of rent becoming due after forfeiture as long as lessor knows that forfeiture has incurred. The correct answer for this question is option D. Can be waived off by accepting of rent becoming due after forfeiture as long as lessor knows that the forfeiture has incurred. Question number 13. In absence of contract or usage to the contrary, the notice period for termination of lease for residential purpose is option A. 15 days, option B. 1 month, option C. 2 months, or option D. 45 days. The correct answer for this question is option A. 15 days. Question number 14. The Privy Council in Mohammed Sher Khan versus Seth Swami Dayal has settled that option A. Section 98 of the Transfer of Property Act 1882 is subject to Section 60 of the Act. Option B. Section 60 of the Transfer of Property Act 1882 is subject to Section 98 of the Act. Option C. Either option A or option B depending on the facts of the individual cases, or option D. Neither option A nor option B. The correct answer for this question is option A. Section 98 of the Transfer of Property Act 1882 is subject to the Section 60 of the Act. Question number 15. The provisions of Section 60A of the Transfer of Property Act 1882 do not apply when option A. The mortgager is in possession of the property. Option B. The mortgager has recovered possession of the property. Option C. The mortgagee has defaulted in receiving payment. Or option D. The mortgager has not defaulted in making payments. The correct answer for this question is option B. The mortgager has recovered possession of the property. Question number 16. The rule against perpetuity as given in Section 14 of the Transfer of Property Act 1882 applies to option A. Immovable property, option B. Movable property, option C. Both option A and option B, or option D. Unconditionally to option A, conditionally to option B. The correct answer for this question is option C, both option A, immovable property, and option B, movable property. Question number 17. Transfer or spes succession is option A, valid, option B, void, option C, voidable, or option D, either option A or option B. The correct answer for this question is option B, void. Question number 18. Under the provisions of the Transfer of Property Act 1882, if there are patent defects in the property, option A, the maxim of caveat emptor will apply, option B, the maxim of ubrime fide will apply, option C, both option A and option B, or option D, neither option A nor option B. The correct answer for this question is option A, the maxim of caveat emptor will apply. Question number 19. A transfers property to B for life and after his death to C and D equally to be divided between them or to the survivors of them. C dies during the life of B. At B's death, the property, option A, shall pass to D, option B, shall pass to any person, option C, shall pass to person who is specifically named in transfer, or option D, none of the above. The correct answer for this question is option A, shall pass to D. Question number 20. The provisions of conditional transfer is provided in the Transfer of Property Act 1882 under which section? Option A, Section 25. Option B, Section 26. Option C, Section 27. Or option D, Section 29. The correct answer for this question is option A, Section 25. That's all for today. I hope you all learned something new. Keep learning. All the best.